4561, State of Ohio versus Connor Grubb. Is there any further witnesses on behalf of the State of Ohio?
Your Honor, before they call witness, before the jury comes in, I did want to put, Ms. Stevens informed me that I needed to put a couple things on the record.
Okay.
Because the next witness, I believe, is Professor Stoughton, right? We would ask that renew our request that the court do an in-camera inspection of his grand jury testimony. You ruled on that, but I believe procedurally we're supposed to bring that up now, as well as renew our objection to the officer created or any type of testimony being allowed into that. We don't believe that that would be appropriate.
Any response on behalf of the state?
Judge, similar response as to our file response as to relating to the grand jury testimony. We would stand on our original response to that. There's not been any particularized need shown. As it relates to the officer created jeopardy, I think the court ruled yesterday that it's not to be considered as a factor, and the court is not going to instruct on that on the jury instructions, but that it can be considered in the totality of the circumstances reasonableness evaluation. And I believe the testimony would be appropriate for that, and we heard testimony yesterday from Davis concerning his opinion as to what it should be considered for.
And I'll note your objection. Anything else we need to put on the record prior to beginning the jury?
I believe so, Judge.
All right, go get the jury.
But you're going to say something that this was the witness we were going to take out of order?
I can.
Does that make sense?
I can't believe we're starting on time. Crazy.
All rise.
All right, everyone can have a seat. Everyone have a good evening last night? Good, good. What we're doing, the next witness was taken out of order. He was unavailable to be here last week, and this would be the state's case in chief. Is there any further witnesses on behalf of the state of Ohio?
Thank you, Your Honor. The state calls Seth Stoughton.
Little maze around here. Raise your right hand.
Sir.
Do you solemnly swear or affirm under penalty of perjury your testimony in this case to be the truth, the whole truth, nothing but the truth?
I do.
Have a seat. Pull yourself up close to the microphone.
Thank you. May I proceed, Your Honor?
You may.
Thank you. Good morning. Could you begin, please, just by stating your first and last name and spelling it for the record?
Good morning. My name is Seth Stoughton, S-E-T-H-S-T-O-U-G-H-T-O-N.
And what is your current occupation?
I am a law professor at the University of South Carolina, Joseph F. Rice School of Law, and I'm the faculty director there of the Excellence in Policing and Public Safety program.
And how long have you been a law professor at the University of South Carolina?
This is my 11th year there.
What courses do you primarily teach, or what are your main areas of research?
In the law school curriculum, I teach criminal law, which is a first-year required class. I teach criminal procedure. I teach police law and policy, and a seminar on the regulation of vice. I've also taught a class called Advanced Topics in Criminal Law, which I haven't taught in a while. It's been 8 years or so. With the Excellence in Policing and Public Safety program, or EPS, I teach principles of leadership and management, collaborative communications. I assist with evidence-based policing, critical incident and sentinel event review, sound agency management, collaborative communications, co-production of public safety. I feel like there's one more that I'm missing in there. Oh, civil rights for law enforcement leaders.
And do you teach exclusively in the law school? Do you do undergraduate as well?
I've taught an undergraduate class. I taught my regulation of vice seminar at our honors college, but no, my work with the law school is exclusively in the JD program and in the policing program.
And Professor Stoughton, going back to the beginning of your law enforcement experience, what did you do prior to becoming a law professor?
I served as a police officer with the Tallahassee Police Department about just under 5 years full-time, and stayed on as a reservist for another 6 months, a part-time officer. I was an investigator with the Florida Department of Education's Office of Inspector General, doing administrative and criminal investigations as it related to the Department of Education, sort of like the internal affairs unit of the Department of Education. And then I went to law school.
And what period of time were you a police officer in Tallahassee, Florida?
That was 2001 until the end of 2005, full-time, and then until May or June, I think, 2006, part-time.
And what type of area is that? Is it big, small, rural, metropolitan?
Tallahassee is Florida City. So it's the city itself is 90 square miles or so. We had 350 or so officers at the agency. The metro population was in the 200,000 to 300,000 range, something like that. I'm sorry, the city population was in that range. The metro area was a little bigger. Mostly suburban, I would say. Little bit of urban for what counts as North Florida urban, and then suburban, with a lot of rural outlying areas that were mostly outside of the city limits.
And what were your roles and responsibilities when you were a police officer within Tallahassee?
I was assigned to the Uniform Patrol Division. I was a Uniform Patrol Officer, which just meant I was in uniform, riding around on patrol, answering calls for service, self-initiating activity like traffic stops or business checks, just your normal beat cop. I had some additional duties beyond the assignment. I developed and taught self-defense classes in the community. I developed and taught some children's self-defense classes. I was a founding member of our special response team, and on that for about 2 years before I left.
And then when and where did you obtain your degrees?
My undergraduate degree was at Florida State, which I started before I became a cop and finished after I was an investigator. So it took me 10 years to get my 4-year degree. And then I went to the University of Virginia for law school and completed that one shockingly on time.
And Professor Stoughton, since you have been a law professor, have you published extensively in your field?
I have, yes.
And what are your primary focuses?
I'm a policing scholar. I study the regulation of policing, which essentially means I look at the legal and the extra-legal rules, things like agency policy and culture that shape officer behavior. A lot of my work is focused on tactics and the use of force, but I've looked at a range of other things, everything from off-duty employment to the development of Fourth Amendment rules that affect policing, to the relationship between state law and agency policy and Fourth Amendment doctrines.
And what type of works have you published?
I've done academic articles both in law reviews, which is the type of publication in my field as a legal scholar, along with criminology articles. I work with a group of criminologists to do empirical work on a whole range of things. I've done book chapters on some of the same topics, and I have co-authored one book.
And is your work extensively cited and relied upon in the field?
Yes.
And do you present on the topics of your focus as well?
All the time, yes. I present pretty broadly, both to practitioner audiences, so especially in the context of use of force review, the Washington, D.C. Metropolitan Police Department does something called their Police Leadership Academy. They bring in 70 or 80 officers from all over the country, and usually about half dozen or so international, for 3 weeks of training. They have me come up to do the use of force review piece. The most recent time is actually pursuits and use of force review. I've done the same thing with regional police leadership trainings with the Charleston Police Department. In a couple of weeks, I'm going to Nashville. There's a Tri-City Police Leadership Academy that's doing the same thing. So I also work specifically with agencies on request. That's one of the things that my program, the Excellence in Policing and Public Safety program, does, is work collaboratively with agencies in South Carolina to provide technical assistance on some of these issues. Beyond practitioner audiences, I present all the time to academic audiences. I was just last week at the American Society of Criminology conference. I present to judicial conferences. I've been here presenting on aspects of use of force reviewed at the Ohio Judicial Conference, for example, to attorneys at both prosecution conferences, defense conferences, combined conferences. So yeah, I present sometimes more than I want to.
And are you regularly involved in actual training of police officers on use of force and tactics?
Not usually with line officers, but often with investigators, supervisors, and command staff on reviewing incidents, yes.
And Professor Stoughton, do you get retained to provide an expert review of officer-involved use of force cases?
Yes, I do.
Roughly how many times do you think you have been retained to provide expert analysis?
At this point, it's hovering around 150 times.
And what type of individuals or entities will hire you for your services?
It's a mix, so it's across, in civil litigation, it may be a plaintiff's attorney or a defense attorney. Plaintiff's attorney being the one who is initiating the lawsuit, suing someone else, the defense attorney being the one who is defending that lawsuit from the plaintiff. In criminal litigation, I've been retained by prosecutors at preliminary review stage, at grand jury stage, at trial stage, as well as by criminal defense attorneys.
And have you offered opinions? Have you offered opinions both that an officer's actions were reasonable and unreasonable? Have you provided testimony as to both sides?
Yes.
And how many times roughly would you say you've testified in court before?
In court is probably around 20 times testifying in trial, 18, 20, 22, maybe, something like that.
What courts have you testified in before?
Oh boy. Georgia State Court, Ohio State Court, Nevada State Court, federal courts in South Carolina, in kind of a lot. I can look at my CV if you want the full list, but sort of all over the place. State court in Pennsylvania and New York, federal court in, I think, Virginia. Yeah, kind of all over.
And in the previous times that you've testified in court, have you been declared an expert?
Yes.
In what fields have you been declared an expert in?
Primarily in police tactics and use of force, or generally accepted practices relating to police tactics and use of force. In a couple of cases, it's been, Minnesota, I forgot about Minnesota. In a couple of cases, it's been police procedures more generally, sometimes investigative procedures or things like that.
Your Honor, at this time, the state would move to have Professor Stoughton declared as an expert in policing and use of force, generally accepted practices.
He can render his opinions.
Thank you, Your Honor. Professor Stoughton, were you retained to provide expert analysis in the shooting death of Takaya Young that occurred on August 24th, 2023?
Yes.
And what is your normal rate that you charge when you're retained to provide expert analysis?
It's changed a bit over the years, but in this case, if you don't mind, I will refer to my report to remind myself of what that is. It depends on when I was retained. In this case, it was $415 an hour.
450.
I'm sorry, 415.
Thank you.
And how many hours would you say roughly you've spent thus far working on this case?
Oh, that's a great question. 35 hours, maybe?
And is that pretty standard?
Yes.
And Professor Stoughton, is your rate, is that kind of industry standard? Is that high, low?
I don't fully know. I know I charge more than some people. I know I charge less than some people. So I think I'm within sort of industry norms on that.
And what is it that you do when you are retained to provide expert analysis? Is it always kind of the same methodological approach?
It is. So usually the retention starts with a preliminary phone call. The phone call is laying out the sort of type of case that we're talking about. There are some aspects of policing where I can help guide an attorney towards an expert, but I am not the guy who is going to be helpful. Assuming that the case is something within my area of expertise, then the question turns to the sort of facts of the case. There are some occasions where I know, even from the preliminary conversation, that I am unlikely to be helpful to the attorney in litigation. So if they want an informed opinion, I'd be happy to share that. But if they're looking for someone to help them make their argument, maybe I'm not the best person. If we get through that portion of the conversation, then there's usually a formal retention, and I'm provided the materials. Usually I get all of the materials in the case. Sometimes attorneys will curate the materials a little bit, so I'll get a subset of the materials in the case. And then the methodology is very consistent. I review the materials. I identify what the issues are. Once I identify what the issues in the case are, then I identify what generally accepted police practices were relating to those issues as of the time of that incident. And then I compare that standard to the officer's decisions or actions to determine whether the officer acted consistently or inconsistently with those generally accepted principles or practices in policing.
And Professor Stoughton, what is the difference between a generally accepted principle and a generally accepted practice?
So generally accepted just means it is broadly accepted in the field. Any reasonably well-trained officer anywhere in the country would say, yeah, that's more or less the way we do things. Policing is a little weird in that way because we don't have a centralized sort of top-down set of instructions. It's not like accounting where there's a book of generally accepted accounting principles. In policing, we identify what's generally accepted by seeing what bubbles up from the bottom to see what practices in the field actually look like. With the difference between principles and practices, principles are a little bit more abstract. They are concepts that inform policy or officer behavior, but they're not specific instructions. So a tactical principle, a generally accepted principle like tactics and using tactics to navigate the dangers of particular situations would be a generally accepted principle in policing. We want to manage officer safety and public safety in a way that balances safety against the police mission, right? Whatever the goal is in that particular interaction. When we're talking about generally accepted practices, that's much more granular. That's a little bit more specific. So in, for example, a high-risk traffic stop context, there is a protocol, a high-risk or felony stop protocol that officers will use that has been developed by policing over decades of practical experience. So it's literally a series of steps, And we would say that's the generally accepted practice in that particular context. Not everything in policing has generally accepted principles or practices, but there are certainly enough areas that do that we can say that is in fact generally accepted.
And as a policing expert, what do you do, or how do you go about determining whether or not a principle or practice is generally accepted in the field?
Yeah, this is where doing a lot of broad review is necessary. So looking at agency policies from all over the country, looking at training documents when they're available or information about police training, sometimes even things like national or representative surveys of officers to identify what's standard in policing, along with looking at the way that we communicate information to police practitioner audiences. So, for example, there are police-specific publications, including non-academic, non-scientific publications like Police Magazine or Police One, that are used to get information to officers about police practices, or that are used to reflect common information between officers. There's also statements from groups like the Police Executive Research Forum or the International Association of Chiefs of Police that will develop model policies or consensus papers. And the important thing to note with any of those is something is not authoritative because the International Association of Chiefs of Police said it. It's not generally accepted because they said it. It's actually exactly the opposite. The reason that the International Association of Chiefs of Police is saying something is because it is generally accepted. That's how it gets into a consensus paper or a model policy.
And are you constantly staying abreast of developments in policing and law enforcement?
Yes, police tactics, police principles and practices change over time. Sometimes they change very abruptly and we can identify a specific incident, a specific point in time. For example, if we look back into the mid-1990s, the police response to an active shooter situation was very, very different prior to the Columbine shooting than it was after the Columbine shooting. So sometimes there are, if you'll forgive the expression, triggering events that lead to a noticeable change in police tactics. But sometimes we just see a gradual shift as technology changes, for example. As body-worn cameras become more standard, we see slight changes in police practices.
And did you apply the general methodology you described in your role as an expert in this case?
I did, yes.
And what materials did you review in this case before rendering the opinion?
There were kind of a lot of materials in this case. I think I have something like 7 or 10 pages of materials. But the very short summary would be video, audio recordings, and written reports.
And did you review video in this case?
Yes.
And Professor Stoughton, did you synchronize the different videos that were provided in this case?
Yes, I did.
And were you able to determine the timing of different events throughout the interaction?
Yes.
And were you able to synchronize the different videos so you could provide screenshots of different videos happening simultaneously?
Yes. So I load the videos into an editing program called VSDC that allows, first it allows you to import the video in their native format, their native frame rate. So if a video comes in at 30 frames per second or 29.97 or 32 or whatever it is, it will load that into its native frame rate. You can load multiple videos into it, and then you can display the videos side by side with run timers. So you can see either how many frames have been going since that video started, or the elapsed time from the start of that particular video.
And did you synchronize Officer Grubb's body-worn camera, Sergeant Moynihan's body-worn camera, as well as the Kroger surveillance video?
Yes, I did.
And how are you able to line up the times in the different videos?
So there are two different sort of things to check when you're trying to line up these videos, right? One of which is you look for audio events, like things you hear on the video recording. If If you know, like an audio waveform, the little stereo symbol, you can use that visually to help identify, particularly when there are peaks in it. You can identify when those peaks overlap between two videos, and then it's a matter of lining up that audio waveform. You also listen to the video as you watch it, and when you have videos where the audio is out of sync, it's very distinctive because you're hearing the same thing ever so slightly off of each other. So when I synchronize videos, I don't turn either of the videos' audio off. I leave all of the audio on and then listen for a complete overlap where it sounds like a single audio source instead of two different audio sources. Now that's when I have audio, and one of the videos in this case, the security camera video, didn't have audio. So without audio, or even in the videos with audio, you're also looking at visual events. You're looking at identifiable events that happen between videos, which might be a door opening or someone's arm moving up and then down, where you can identify in the video the frame at which the hand hits its apex before going down, and you can line those up between videos.
And were the embedded timestamps in the different videos consistent with one another?
No, not at all, and that's actually very common. The embedded timestamps, even in two videos, like two body-worn camera videos with the same manufacturer, the embedded timestamps will be fractions of a second or even entire seconds off. In this one, I'd have to go back and look, but the timestamp between the security camera video and the body-worn camera video was substantially misaligned. So you'll see different times in the embedded timestamp at the same time that the same events are happening.
And will you always synchronize video when you're retained as an expert to assist you in your analysis?
Not always. Sometimes synchronized video is provided for me. Sometimes there's only one video, there is nothing to synchronize, or there is no overlap in videos, so there is nothing to synchronize. But it's pretty common. I would say I do it in the majority of the cases where there's multiple videos.
And did you provide freeze frames in your report of the different videos at the same time?
I did, yes.
And were those put into a PowerPoint?
I did not put them into PowerPoint, but yes, they were.
Your Honor, may I publish this as demonstrative evidence to assist with the testimony?
You bet.
Professor Stoughton, what are we looking at this screenshot you provided here? Is this kind of a setting of the scene?
It is. So I will break down the different little pieces of it. So in the bold, what you see is the source of that video. This is Kroger parking lot security video. Then you see the timestamp that is on the video itself, which is 18:27:48. The number in the parentheses is the runtime of this video. That is, at this particular frame, this particular video has been playing for 13 minutes, 47 seconds, and 0.700 seconds. Cropped and marked underneath that indicates what I did to this image. So I cropped it, which is why you don't actually see the embedded timestamp. That is, I've zoomed in a little bit on it, and marked because I have labels that obviously do not actually appear in the original video. So the labels with their little arrows point to different things of note. And yes, this is relatively early on, sort of setting the stage for the reader of the report.
And is this shortly before the use of force incident occurred?
It is, yes.
And what are we looking at these freeze frames?
So this is the point at which Officer Grubb has moved in front of the vehicle, as visible both from his body-worn camera on top. Again, you can see the title of the video, the runtime, the parentheses, the embedded timestamp, the parentheses is the runtime, and then both of these videos are cropped. This is the Officer Grubb's body-worn camera on top and the Kroger security video on bottom.
And have we moved slightly forward in time here?
We have, yes. So if we the easiest way to sort of track the time, for me at least, is to look at the runtime, the number in the parentheses. So here, Officer Grubb's body-worn camera on top, that is not cropped. That's the full picture of his body-worn camera. And then on bottom is the Kroger parking lot security video at the same point. That one is cropped, and obviously you will note that the quality is not perfect.
And what has happened thus far at this point in the screenshot?
So at this point, Ms. Young has turned the steering wheel to the right. Officer Grubb has drawn his firearm, and you actually see it there in his right hand in his body-worn camera at the very top right of that picture. You can see his arm out with the firearm pointed.
And had the vehicle moved at all yet?
I don't believe it had moved at this point. I can look at my report to make sure, but I don't think it had edged forward initially. If you'll give me just a second, I'd like to confirm that. Sorry, it's a long report. Give me just a second. No, I don't believe so. Wait, sorry, I'm just checking. Yes, I'm sorry. I believe her vehicle had edged forward at that point, at the point where he puts his hand on the front.
Does the putting of the hand on the front of the hood happen right after the vehicle first moves forward?
I think it happens after the vehicle moved forward for the second time. So the vehicle sort of moves forward a little bit, stops for a second, and then moves forward again, and the hand goes on the vehicle, as I recall, after the vehicle starts moving the second time.
What are we looking at in these videos?
So this is a lot. The page is very busy, and I apologize for that. But this is synchronized videos where they are synchronized in horizontal order. So on that top row there, all of those videos are depicting things that happen at the same time. And that's true as you go down every row. So although the embedded timestamps and the run times are obviously different because the videos have different embedded timestamps and they start at different places, what you're seeing is screenshots of the synchronized video. This is not every frame of the videos. This is instead every 0.2 seconds, every fifth of a second. There's a jump to sort of the next row. So there are some frames in between these.
And what is happening right now during these synchronized screenshots?
So you can see in the leftmost column, which is the Kroger parking lot security camera video, you can see Miss Young's vehicle moving forward and to the right. In the middle column, that's Officer Grubb's body-worn camera. You can see the perspective from his body-worn camera. And on the right is Sergeant Moynihan's body-worn camera, so you can see the perspective of that camera depicting the same incident at the same time, but from different perspectives.
And are these rows moving forward in time?
Yes, every row moves forward 0.2 seconds. So if you look at the embedded timestamp, it's not super helpful because I'm breaking things into smaller than 1 second increments. But if you look at the runtime, that number in the parentheses, you'll see, for example, the Kroger parking lot security video goes from 1414.533 to 1414.733, 0.933. That's just that jump forward in 0.2 second increments.
And does this series of screenshots lead up to the moment that deadly force was used?
It does, yes. This is a continuation. All we are doing is advancing time in that 0.2 second, that 0.2 second increments. So you can see again the vehicle continuing to move to the right. Officer Grubb sort of moving to the right, his hand remaining on the vehicle there. And from Sergeant Moynihan's, you start to see aspects of where, like in the third column, second row, you can see a little bit of where Officer Grubb was.
That's the one we were previously on, was it not?
Yes. So there were 3 pages of that 0.2 second progression, right? I think we skipped through either the second or the third one of those, but that's what they show.
That'd be the first one.
That's the first one. And then the second one, and then there's one, so that's the one that we were just looking at where you can see Officer Grubb in column 3, row 2. And then there should be one more.
And is that where you can see Officer Grubb? Is that Sergeant Moynihan's body cam?
Yes, Sergeant Moynihan's body cam, the center most row there, you can see Officer Grubb.
And then the Officer Grubb video in the centermost row, is that at the exact same time as you see Officer Grubb on Moynihan's body cam?
Yes. And this is the third of the 3 pages. Again, it's continuing to show the same thing, just different events because time is progressing. So here you can see Miss Young's vehicle continuing to move forward. Officer Grubb now sort of moving over to the left of the vehicle, both on the Kroger security camera video, on his video, and you can see it on Sergeant Moynihan's video.
And is this still before deadly force had been used?
It is, yes.
And what do these screenshots?
So these are the 2 frames. This is now not separated by 0.2 seconds. It is instead separated by 0.033 seconds, which is 1 frame of these 2 videos. And it's the difference in frame, the frame immediately before the shot and the frame immediately after the shot. That is, there is no frame of the video between these 2 things, right? It is literally 1 frame to the next. In the top frame, we do not have the bullet hole in the window. In the bottom frame, we do.
So here can we see that the shot occurred between this 366 thousandths of a second and 4 thousandths of a second?
Yes.
And what is the timing of when the gun was discharged? How do you have that indicated?
I'm sorry, I'm not sure I understand your question.
Do you use, well, I guess you could use run length of the actual video, run length of the synchronized video?
Oh, yeah, so you can, I mean, if what you're asking is just how do we identify when that shot was fired, we can identify it on that body-worn camera video, right? The runtime of 5 minutes, 33 seconds, and 0.4 of a second. We can also use the runtime for the approximately synchronized video, which has a different runtime because that entire approximately synchronized video starts at a different spot than this particular video.
So is the 5 minutes, 33.4 seconds, is that the runtime of Officer Grubb's body-worn camera?
It is, yes.
And is that the time you can pinpoint that the shot was actually fired?
I think the better way to put that would be we know that by that point the shot had been fired, right? I have about a 30th of a second there where I don't know exactly where in that time the shot was fired, but I can tell you it hadn't hit the glass on the top frame and it had hit the glass by the bottom frame.
Were these screenshots of where the car finally came to rest after force was used?
Yes, that's correct.
And Professor Stoughton, what are we looking at here? Is the in relation to the moment that deadly force was used?
Sure. So this is now, instead of presenting all 3 videos separately, this is consolidating the 3 videos into my, what I refer to as the approximately synchronized video. Approximately because I still have I still have a 30th of a second of play just on the nature of when those videos start and stop. So this is as close as I can synchronize these videos. And what you see, if you look at Officer Grubb's body-worn camera, the runtime there, the top one is 5:33, 5 minutes, 33 seconds, and then 0.333 seconds. That's slightly before the 0.366 that we saw earlier. It is one frame before that. The bottom one is the 5 minutes, 33 seconds, 0.4. And you can actually see in the corner there the bullet hole. That is the first frame of that video in which the bullet hole appears on the screen. So this tells you what was happening on all three cameras, looking at them simultaneously, 2 frames before, and then the first frame at which the bullet appears, the bullet hole, excuse me.
So then is Moynihan's body cam at the bottom? Does that show Officer Grubb at the moment the bullet hole appeared in the windshield?
Yeah, so in the bottom compilation of videos, that is approximately synchronized video, 14 minutes, 16 seconds, and 1/10 of a second, 0.100, that shows all three videos at the same time. So you can see the bullet hole on Officer Grubb's, which is the top right image, and you can see a little bit, at least, of Officer Grubb's positioning in Sergeant Moynihan's video, which is the top left image, along with the not cropped, so it's zoomed out version of the Kroger video at the bottom of those three.
And then here, is this actually immediately after the gun was discharged?
Yes, so this is 0.266 seconds after that bullet hole appears in the windshield. And maybe the easiest way to track that is, again, looking at Grubb's body-worn camera video. In the runtime, we saw the bullet hole appear at 5:33.4. This is 5:33.666, so that's 0.266 seconds, just over a quarter of a second.
And where can you see Officer Grubb on Sergeant Moynihan's body camera?
Sergeant Moynihan's body-worn camera is the top left image there. You can see Officer Grubb sort of to the side near what I would describe as the front quarter panel of that vehicle, the driver's side front quarter panel.
And how long was this after the bullet hole appears in the windshield?
It was 0.266 seconds, just over a quarter of a second later.
Professor Stoughton, after you reviewed all of the materials in this case, based on your training, education, and experience, were you able to render any opinions?
I was, yes.
And what were the opinions that you rendered in your report?
As you see them displayed on the screen there, I had 2 opinions, one of which related to Officer Grubb's decision to move in front of and take a position in front of Ms. Young's vehicle. That was tactically unsound. It was unreasonable. It is unjustified risk-taking under the circumstances, and it's a position that is foreseeably likely to contribute to a officer-involved shooting. The second one relates to the decision to remain in front of the vehicle and to use deadly force rather than to get out of the way of the vehicle when that's an option. That's what we expect officers to do. So that decision to draw his firearm and then use deadly force as opposed to moving out from in front of the vehicle where he had put himself is also just professionally inappropriate and not consistent with generally accepted practices.
Now, Professor Stoughton, to break down the first opinion first,
Sure.
could you describe or define what tactics are in the world of policing?
Sure. Tactics, in a nutshell, are how officers manage the risks of a situation and how we balance priorities. So one priority is for the officers to do whatever it is that they are trying to do. That might be investigate someone or serve a search warrant or apprehend someone, whatever the sort of police mission is in that particular context. But there are also risks and dangers and the potential for threat in any type of police action. So we use tactics to try and advance the police mission in the way that is safest for the officer, for the public, for the suspect themselves. Tactics are how we engage in that balancing. That's kind of abstract and academic. So the practical way is tactics are how officers keep themselves and the public safe while doing the job that we want them to be doing.
And are the reasonable tactics to use, and is it always context dependent?
Yes, absolutely. There are entirely different tactics that we expect of officers, for example, in an armed barricaded subject situation, as opposed to an active shooter situation. It would be wildly inappropriate to use reverse tactics, right? With an armed barricaded subject, you set up a perimeter, you take lots of time, you have negotiators, you set up lines of communication. You don't do any of that with an active shooter situation, right? So the tactics are very much geared towards the facts of a particular situation.
And when you are asked to provide an expert analysis on whether or not an officer's actions were reasonable, do you offer your opinions on what the best tactics should have been or what the reasonable actions should have been or were?
No. My opinion is based on what the generally accepted practices were at the time. That is what's reasonable at the time, keeping in mind that reasonable is not best. It is unrealistic to expect officers to make the best possible decision, especially in a high-stress, time-pressured environment. But they still have to be professionally appropriate and make reasonable decisions and take reasonable actions in those situations. So we don't expect in this context, right, when I'm assessing a case as an expert, I'm not looking for best possible outcomes. I'm not applying best practices. I'm looking at what the field has generated as generally accepted in that particular context.
And is there, in any given situation, is there typically a range of reasonable responses?
Yes, very often there's an entire range. It could be that X was reasonable, Y was reasonable, and Z was reasonable. The right way to think about reasonableness, I think, especially in the police tactical context, is not as a coin, right, where on one side you have heads and that's reasonable, on the other side you have tails and that's unreasonable, but instead think of it much more as a spectrum. There's a range of reasonable options, some of which might even be more reasonable or less reasonable, but there's a range of reasonable options. At some point on that spectrum, however, there is a line that says there's also a range of unreasonable options. So to a significant extent, what I'm trying to do is figure out, based on what generally accepted practices were at the time of the incident, where on that spectrum an officer's decisions and actions should be plotted.
And how, in the world of policing, how do you go about assessing someone's tactical decision making?
So I can give you the complicated version or the simple version. The complicated version is you actually do something of a decision tree, right? You look at the different points at which an officer acted or made a decision, and you ask whether, under the context of this situation, that decision was appropriate or inappropriate, whether it was reasonable or unreasonable, whether it was consistent or inconsistent with generally accepted practices. The way that you actually answer each one of those questions at the different points in the decision tree for tactics is basically weighing the tactical benefits against the tactical costs. It's kind of risk-benefit analysis or cost-benefit analysis. What are we going to get out of this, and what kind of danger might it create? That's important because we expect officers in many circumstances to put themselves in harm's way, and it's professionally reasonable and appropriate to do so. The active shooter situation that I mentioned is sort of the best possible example of that. It is very dangerous for officers to rush in somewhere when they're dealing with an active shooter. But we expect them to do that because we view the danger created by the officer's actions as worth the potential risks. Saving the innocence from the active shooter are worth that danger. In other situations, it doesn't make sense for an officer to take risks when they aren't justified by the situation. So one example that I use in training is if an officer is trying to apprehend a jaywalker and he sees someone jaywalking and then the light changes, and the only way that the officer could go and apprehend that jaywalker is to throw himself into traffic on a busy road with cars traveling at high speed. And if he doesn't do that, the jaywalker is going to get away. Well, in that case, it's still not worth the risk of doing that. Stepping into traffic is very high risk, and the reward of apprehending a jaywalker is pretty modest, right? So in a situation like that, we would say the risk vastly outweighs the potential benefits.
And is it generally accepted in policing that situations are often dynamic, so a tactical decision-making can change as that same situation continues to develop?
Yes, absolutely. Officers' decisions have to evolve as a situation evolves. There are situations where it may have been tactically appropriate to take one position, but it's not tactically appropriate to stay in that position, for example, right? The fancy police terminology is often tactical repositioning there. You were fine here, now you're not fine here, so you move to another area that provides some tactical advantage. Yeah, officers have to change and adapt as the situation changes.
And is it also, in assessing an officer's tactical decision-making, is it generally accepted in the realm of policing to avoid hindsight bias?
As you're reviewing an officer's incident, yes, you want to avoid hindsight bias. Hindsight bias is this really pernicious little human cognitive bias that it affects the way we view things based on the outcome of those things. And that was wildly academic, so let me try and break that one down just a little bit. When we're analyzing an officer's actions, when we look at that point in the decision tree, we ask, was that an appropriate or reasonable decision based on the information that we knew at the time, based on the information reasonably available to the officer at the time? We don't ask whether it was a good decision based on the outcome of that decision, because sometimes a good decision can still have a bad outcome. That doesn't make it a bad decision. It was a good decision at the time, even if it led to a bad outcome. The same thing is also true in reverse. Just because there's a bad decision does not mean that it's a good outcome and therefore everything is okay, right? A bad decision is still problematic and potentially worth addressing, even if the outcome worked out just fine. So hindsight bias is the potential for the outcome and our knowledge of the outcome to affect the way that we evaluate the decision at the time. And we have to address it by being very deliberate about looking only at the information at the time and separating it from the ultimate outcome.
So does avoiding hindsight bias mean that officers' decisions can't be reviewed and assessed at all?
No, absolutely not. To avoid hindsight and what the Supreme Court has referred to as the 20/20 vision of hindsight, all that means is we don't use information developed after the fact to assess an officer's decision-making, because the officer couldn't have been aware of that information at the time. That is, that information couldn't have affected their decision-making because they didn't have that information. So that's what we mean by avoiding hindsight in use of force review.
And then, Professor Stoughton, when it comes down to policing tactics, how does the element of time factor into it?
Time is the most important tactical concept. Time is what officers need to make better observations, to go through a better decision-making process, to get the additional resources that they may need to deal with a particular situation, even to move from one position to another, right? That takes time. So a large focus in police tactics is in creating time, giving officers more time to address a particular situation. A use of force incident can happen very, very quickly. The phrase that's often used is split second, right? It can happen in a split second. Tactics, to a very significant degree, are designed to avoid putting officers into a position where they have to make an actually split-second decision. The goal is to give officers as much time as the situation allows so that they can make the best possible decision and a professionally reasonable and appropriate decision in that context.
And then in that same regard, what is tactical restraint?
Tactical restraint is the idea that sometimes moving forward is not the best tactical approach, that it can create some dangers that are not justified in the situation. So if officers could go into one position that is dangerous or they could stay in a position where they have some relative safety, they have some tactical advantage, tactical restraint would say, well, unless that moving forward and taking the dangerous position is specifically justified, unless there's some compelling reason to do that, you should actually exercise restraint wait the few more seconds or minutes or whatever it is to maintain that tactical advantage, which might be improving officer safety or public safety or the safety of the subject.
And Professor Stoughton, can you just describe to the jury what is the concept of officer-created jeopardy?
Sure. Officer-created jeopardy is just a phrase that refers to unjustified risk-taking. It's not a magic phrase. It doesn't have any independent meaning. It's a term of art that was developed by the Savannah Police Department in the early 1990s that refers to officers putting themselves into positions where the dangers outweigh the benefits, right? It is a risk-taking behavior that is not justified under the circumstances.
And if someone were to state that that is purely an academic concept and isn't present in peace officer training curriculums, what would your response to that be?
I think that's wildly ill-informed. Tactics made their way into police training when we started formalizing police training in the 1920s. The very earliest records of formalized police training have a discussion of tactics, and tactics are about making professionally appropriate risk-balancing decisions, right, about not taking unjustified risk. So we see in the annals of criminology from 1929 a discussion of police tactical training. We see an explosion in police tactical training starting in the 1960s and then really getting into the 1970s with practical work by, among others, NYPD Lieutenant Jim Fife, who developed a whole set of tactical principles in his work at the NYPD to help address an increase in officer-involved shootings. In fact, Jim wrote an essay on the split-second decision-making that he called the split-second fallacy, pointing out tactics are what save us from making split-second decisions, right? So we use good tactics to avoid putting ourselves into time-pressured situations where we can't figure out how to respond, so we may have to escalate in a way that if we took a more restrained, a more tactically sound approach, we wouldn't have to at all. Tactics are part of the training of every police academy in the country, including here in Ohio in the basic officer certification program. There's an emphasis on tactics and approach. You don't always see or hear the phrase officer-created jeopardy, but that's because the vocabulary is not universal. The concept is certainly universal. In the same way that when we're talking about when officers walk up to a car, a lot of places call that an approach, and some of the Ohio training material refers to it as a walk-up. It's not the vocabulary that's important, it's the concept that that vocabulary is trying to express.
And did you review some Ohio peace officer training curriculum materials in the course of this case?
I did, yes. My understanding is they were the materials in play at the time of Officer Grubb's basic recruit training.
And did you observe tactics in there consistent with generally accepted principles and practices?
Yes.
So if not the term officer-created jeopardy, are you saying that concepts related to officer-created jeopardy are prevalent throughout peace officer training curriculums?
Yes, absolutely. The idea that officers should use good tactics and that using bad tactics can put officers into unnecessarily dangerous situations, which is why we use good tactics, is ubiquitous in policing.
And what is the generally accepted position in policing on officers placing themselves in front of a vehicle's path of travel?
Don't. It's very straightforward. Vehicles can run you over. They can hit you, they can drag you, and that's a capital B bad thing. So the way to remove that as a possibility is to not move into, and certainly not to remain in, a vehicle's path of travel. Don't be in front of the vehicle, don't be behind the vehicle. Vehicle can't really hurt you if you're standing next to it, so do that.
Is this a topic that has been considered extensively in the realm of policing?
Yes, absolutely. It pops up in training presentations by the Police Executive Research Forum. Going back at least to the late 90s, there's a discussion of officers not standing in front of vehicles. There are articles in police media from 2005, 2006, all through the 2010s about not taking or maintaining a position in a vehicle's path of travel. The basic rationale for all of that is standing in a vehicle's path of travel will typically offer very little in the way of tactical advantage. It might offer some, depending on the situation, but it's typically not going to be much different than the tactical advantages offered by standing next to a car. But it exposes the officer to a substantial amount of tactical risk. Again, vehicles can hit you or drag you or run you over if you're standing in front of them or behind them. So when the risk outweighs the tactical benefits, as a general matter, police tactics would say, don't do that.
Are there any tactical benefits to an officer placing himself in a vehicle's path of travel?
There can be, depending on the situation, but it's often pretty modest. There can be some visual benefit. Maybe the officer gets a perspective that they can look into a vehicle that they might, in a way that they might not otherwise be able to. That does have some tactical benefits to it. However, if the officer can look into other windows, whether those windows are open or there are other officers looking in, or the windows are not darkly tinted or mirror tinted or something like that, we can't ignore the fact that we might get the same tactical benefits from a different position, right? It may not be the only way to get that tactical benefit. One of the tactical benefits, I suppose, is communicating to the person in the car, hey, you're not free to leave right now because here I am standing in front of you like a human traffic cone. Again, that might have some tactical benefit, but it's not really distinct from the tactical benefit of telling someone the same information while not standing in front of the car. Minimal tactical benefit, maybe no increase in tactical benefit, and again, exposing officers to a substantial amount of risk. Depending on the situation, there may be some other tactical benefits, but usually they're relatively modest. And there is always a substantial risk of the car moving unless the car is inoperable, right? If the car is inoperable, then it doesn't have a path of travel, so we get the same tactical benefits without those tactical risks.
And how is an officer standing in front of a vehicle, how does that relate to the concept of officer-created jeopardy?
Sure. So again, officer-created jeopardy just referring to unjustified risk-taking, or the idea that the position of an officer has to balance the risks of that position or action against the benefits of that position or action. If an officer steps in front of a vehicle when the tactical risks substantially outweigh the tactical benefits, we'd say that is not justified risk-taking. And the term of art that we might use there is, that's an example of officer-created jeopardy. In fact, in the book that I wrote, which is Evaluating Police Use of Force, my co-authors and I use this example exactly as the paradigmatic example of officer-created jeopardy. There was an officer, Kimberly Rasso, who was working off-duty at a mall and investigating a shoplifting incident, and stepped in front of a car and ended up shooting the driver when the car moved towards her. And the point is exactly, the tactical benefits are pretty limited. Not that there's no goal in stopping that car and apprehending that shoplifter. Of course there is, but the tactical benefits are substantially outweighed by the risk presented to the officer, especially when it's foreseeable that if the car moves forward and the officer says, oh, I'm in danger, and uses deadly force, now we've just shot someone in a shoplifting investigation.
And Professor Stoughton, what is considered a better position or the generally accepted practice when it comes to approaching a vehicle?
So there are a ton, and again, this is where there are a whole range of reasonable options rather than a specific reasonable option. If officers are trying to maintain visual contact, that is, they're trying to look into the car, and we have two officers, right, where one of them, in this case Sergeant Moynihan, is standing on the driver's side of the car, it's possible, but maybe not highly beneficial for the two officers to just stand next to each other, right? More tactically beneficial would be a sort of standard traffic stop approach where you have an officer standing on either side of the car. Officers certainly want to avoid the potential for a crossfire situation, but there are a number of ways to do that, including standing in front of what's called the A pillar, which is that line of metal between the windshield and the driver's window, or the windshield and the passenger window, right? If both officers are standing in slightly in front of that A-pillar, they still have visual contact from both sides, and also are not in a position where, in the event of gunfire, they will be aiming at each other. Same idea, you can have officers standing behind the B-pillar. The B-pillar is the line between the driver's window, the driver's window and the driver's side rear passenger window, or the front passenger window and the back passenger window, right? If officers are stepping back a little bit, they can look into the car, keep the visual, and also not put themselves into a crossfire situation. Or some combination where you have officers not like this, but in sort of a V shape, if that makes sense.
And we talked about the general position in policing on an officer situating himself in front of the vehicle's path of travel. What about the defendant's decision to situate himself in front of a vehicle in this particular case?
It's a really bad idea. The tactical benefits are marginal or modest at best, and the tactical risks are substantial.
And Professor Stoughton, if someone were to claim that standing in front of the vehicle was the best tactical position in order to potentially avoid crossfire, what would you say to that?
Not when you have motorists sort of immediately behind the vehicle in the line between the position in front of the vehicle, the driver of the vehicle, and what's known in policing as the backdrop or the backstop. That is the thing behind your potential target.
And do you have the person marked here in this screenshot?
Yes. So over on the bottom left, you can see the person with the little tag, the mark as motorist. That's a motorist associated with the car that the officers had been helping with just a few minutes ago. You can also see in the sort of yellow top there, I believe that's the Kroger employee. Additional, if minor point, Autoglass does some really weird things to bullet trajectories, so we don't always know where the bullet is going to go after it strikes, well, anything, but especially not the glass or metal from a car.
And does a tactically sound position approaching a vehicle eliminate the possibility that the vehicle could even be perceived as a threat?
Yes. If you remain to the side of the vehicle cannot run you over. It lacks what we refer to as the opportunity to be used as a weapon against the officers.
And is the goal of tactics to conclude a situation in the safest possible way?
Yes, to try and achieve the police goal in a way that appropriately balances public safety, officer safety, and the safety of the subject with whom officers are interacting. To do so in what is hopefully the safest and least intrusive way.
And what is the what is the generally accepted position in policing about how far officers should go in order to investigate a crime or apprehend a subject?
So it very much depends on the situation. I know I'm going to sound a little bit like a broken record, but the ultimate question is, are the costs worth the benefits, right? Especially keeping in mind that when officers are doing some kind of field investigation, there are different risks that officers may be worried about. One of the risks is being run over by a car. Another of the risks is the person that officers are investigating getting away. If we look at that, the risk of getting away, we want to stop that, right? If someone is going to be investigated or arrested for an incident, whatever criminal incident that is, that's certainly a police priority. But just like every other police priority, it's not a priority that we expect or want officers to pursue at all costs. They have to do so in a professionally appropriate way. And just because, in a situation like this, just because a motorist does leave does not end an investigation. It's really a false choice to say officers either have to put themselves in life-threatening danger or they lose any ability to investigate this incident at all. Most shoplifting incidents are investigations that officers conduct after the suspected shoplifter leaves. So you use security camera footage or witness testimony to identify who your offender is, and you go and get a warrant in a normal investigative process. Like the jaywalker, the choice of like, do I just let him get away or do I create extreme danger to myself? There's kind of only one professionally appropriate answer to that question. But unlike that jaywalker hypothetical, it doesn't end with just letting them get away, right? It's not a police endorsement of the underlying activity to do an investigation that will result in a later apprehension. So we should specify that the risk of getting away isn't the risk of getting away scot-free and never getting caught. It's just the risk typically of delayed apprehension after investigation.
And does policing in developing generally accepted practices and principles, does it incorporate cases from the United States Supreme Court?
Yes, policing, so the standard that I'm applying is this generally accepted principles or practices in policing. Policing as an industry is certainly responsive to law. That is, principles from some of the seminal use of force cases by the Supreme Court have been incorporated into those generally accepted practices.
And has the Supreme Court spoken to this concept of weighing the balances against when to continue trying to investigate or apprehend someone?
It has. So in a 1985 case called Tennessee v. Garner, the officer in that case was investigating a reported home burglary, saw the burglary suspect fleeing from the house and starting to climb a fence, and knew at the time, if this guy jumps the fence, I'm not going to catch him. He is going to get away. And potentially, especially maybe given the state of investigative techniques and technology at the time, if he gets away, he's going to really get away, right? There's unlikely to be a later apprehension. In that case, the officer shot and killed Edward Garner, and the Supreme Court said that that was unconstitutional, and their line in balancing that you're asking about is, it is not better that all felons die than that they escape. That is, sometimes, in balance, to avoid killing someone, we just don't solve the crime at all. Now, again, that's a very different situation here, where we have at least a witness standing by to provide information and video.
And my next question was going to be, in this case, had Ms. Young left, were there other investigative avenues that still could have been pursued?
Yes, absolutely. It does not mean for sure that they would have identified her and been able to apprehend her later, but yes, there was a professionally reasonable likelihood of being able to do exactly that.
And does this particular case illustrate why policing has the generally accepted position on standing in front of the vehicle that it does?
I believe it's actually an excellent example of why that principle exists, right? Why we have the practical guidance to not stand in front of vehicles, to reflect some of the points made in those 2005, 2006 articles that I mentioned. The human body is not going to win that interaction, right? You are not going to be able to stop the mass and power of a vehicle. Knowing that you can't actually have that effect, why would you put yourself in the position of being exposed to that degree of danger? Just stay out of the way and you can approach the situation a little more safely.
And what would you say to an explanation that it was done either to convey to Ms. Young that she wasn't free to leave, or to be able to see into the vehicle?
Sure, and as I mentioned, both of those provide some tactical benefit. But when you already have one officer who's telling someone that they are not free to leave, standing in front of the vehicle doesn't add very much to that information, right? It's not like she was unaware of that until someone stood in front of the vehicle.
Please. You can approach.
Thank you.
Professor Stoughton don't testify as to what Takia Young was aware of and those kind of things.
Yes, Your Honor, I apologize. That was inartfully said. What I should have, and what the way.
Your Honor, is there a question being asked?
You can ask a question.
I would say, was that information already being communicated to her?
Yes, and an officer applying generally accepted principles would certainly be aware that that information was being communicated.
Objection, Your Honor.
Overruled.
And Professor Stoughton, is your opinion in number one, is that to a reasonable degree of professional certainty?
It is, yes.
And now, moving to the... What is your second opinion?
The second opinion focuses on the decisions to draw the firearm and to use deadly force rather than remove oneself, Officer Grubb removing himself from that position in front of the vehicle.
In policing, to unpack that, in policing, when is an officer permitted to use some force?
So any amount of force, right, the goal of any amount of force is to address the threat presented by a subject's actions. Officers have a particular set of goals. They might depend on the situation, right, but it might be to stop someone, to investigate them. It might be to conduct a search. It might be to arrest someone. It might be to protect property, protect someone from being injured, etc. When someone's actions present a threat to one of those police goals, the officer can use force to address that threat. Policing defines threat in a fairly particular way. That is, a threat exists or a threat is imminent when the officer would reasonably perceive in that situation that the subject has the ability and the opportunity and the apparent intention to cause whatever type of harm we're worried about. Ability here really refers to physical capacity. Someone with a knife has the physical capacity to stab an officer, to cause that kind of serious bodily injury. Opportunity refers to whether someone is vulnerable to that particular type of harm. So someone might have a knife and have the physical ability, but if they're 60 feet away, they do not have the opportunity to inflict the stabby stabs that we're worried about with that knife, right? Intention is exactly what it sounds like. Can we tell from the person's actions that it looks like they might want to inflict that particular type of harm? So someone who has a knife, who is within arm's reach of an officer, but they're chatting about burglaries in the neighborhood while the person is cutting up carrots for dinner, has the ability and opportunity, but not the apparent intention to use the weapon. All three of those components are necessary to establish a threat, because in the absence of any one of those, we have the potential for threat. We have what's referred to as risk. And officers have to deal with risk all the time. Every scene that they drive up to, someone could potentially have a gun, right? So we use tactics to manage risk, and the use of force is appropriate when the person presents a threat or an imminent threat of some particular type of harm.
So what are, under generally accepted practices, what are the steps in evaluating a use of force?
So the first is to look to see whether the officer has a sort of legitimate police goal. Are they trying to do something that they're allowed to do? The second is, okay, if the police have some legitimate police goal, are the person's actions, is that in that circumstance, do they present some threat to that police goal? Are they going to delay or defeat the officer's attempt to investigate or apprehend? Are they going to injure someone, including the officer themselves, right? Once we identify that there's an imminent threat to some legitimate police interest, then we can say, okay, some amount of force may be justified here. It does not mean that any amount of force is justified, because the next question would be, if some amount of force is potentially justified, is the nature and severity of the force used appropriate or proportional to the nature and severity of the threat being presented? And this is sort of a sliding scale of severity, right? The more severe the threat, the more serious force officers can use.
And we've touched on this a bit, but what are the operative facts to be considered in evaluating the use of force?
So when you're talking about the operative facts, we really mean how should we understand that situation, right? Particularly if there are disputes about what the facts are. And the operative facts are the information that was reasonably available to the officer at the time. That is, if we take the actual officer and we pluck them out of the situation and we drop into the situation this sort of construct that we call the reasonable officer, what would the reasonable officer at the time have perceived and concluded?
And has policing also incorporated Supreme Court case law when it comes to the generally accepted practice in evaluating the use of force?
Yes, absolutely. The idea of using that hypothetical reasonable officer as a construct, of using the facts as known to the reasonable officer at the time, that predated the Supreme Court, but the Supreme Court adopted exactly that framework in a 1989 case, Graham v. Connor, and policing adopted that same framework.
And so does that framework, considering the use of force from the perspective of an objectively reasonable officer, does that take into account specialized training, education, and experience that an officer would have that a layperson maybe would not?
It does, yes. The idea is what the officer would perceive and conclude, keeping in mind that officers may perceive things differently and may conclude things differently than non-officers. For example, a non-officer might view a particular interaction and say, oh, that's a weird little handshake, and an officer, on the basis of their training experience, might say that was actually a hand-to-hand drug transaction. But the reason that I know that as an officer is because of my training and experience as an officer. So we do use this framework not of the generically reasonable person, but the reasonable officer in that situation.
And Professor Stoughton, in this case, in evaluating the use of force, how do you identify the severity of the use of force?
So in this case, it's actually very simple because we have the discharge of a firearm, and that is deadly force. Deadly force is any application of force that is substantially likely to result in serious bodily injury or death. Discharging a firearm certainly fits.
And is it generally accepted in policing that an officer can only use force if there's some type of imminent threat?
Yes.
And I think you actually answered in part of one of your answers, when is a threat imminent?
A threat is imminent when we have that ability, opportunity, and intention. The way to think about that is it does not require someone to be actually stabbing an officer already. It doesn't require the person to have pulled the trigger on the gun. The officer is allowed to intervene and use force to prevent that from happening, but the person still has to have and display the ability, the opportunity, and the apparent intention to do that thing, right? So if we go back to the knife example, someone who's sitting in the living room talking with the officer and there's a knife across the room does not at that point have the ability. That is, the ability to stab the officer. On the other hand, if they bolt for the knife and grab it, that's a pretty good indication that they now have the ability and potentially the intention to use that knife in the context of that situation.
And what is I think you also touched on this, but what is a risk as opposed to a threat?
Risk is just the presence of any one of those characteristics, ability or opportunity or intention, but not all three. And officers, one of my favorite quotes about this is, officers operate in risk soup. They're constantly surrounded by risks, which is why it's so important to use tactics to manage those risks and to prevent those risks from becoming threats, because threats are what give rise to actual harm.
And in determining whether or not a threat is imminent in policing, does that depend on the facts and circumstances of each particular case?
Yes, very much so.
And is that both from the United States Supreme Court and incorporated into the world of policing?
Yes.
And in evaluating the use of force, what portion of the encounter is reviewed?
All of it. You want to look at everything that led up to or potentially contributed to that use of force. Obviously, the subject's actions, because that's where we get our nature of resistance and threat, and also the actions of officers or potentially even bystanders that may have contributed to that.
So does evaluating the reasonableness of a use of force incident, does that involve evaluating decision-making from the beginning of the interaction to the end?
Yes, it certainly should.
Carmen, how are you doing?
Anytime.
Let's see. Approach. Carmen rules. We'll take a 15-minute break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it's finally submitted to you. 15 minutes.
All right.
can I have a seat? Professor Stoughton, you're still under oath.
Yes, Your Honor.
You may inquire.
Thank you, Your Honor. Professor Stoughton, I believe when we left out, I was asking, in policing, when evaluating the use of force, what part or what portion of the interaction are we supposed to review?
All of it. The phrase that's typically used is totality of the circumstances. Totality of the circumstances review, we look at all of the contributing events that led up to it, the subject's actions, the officer, the entire set of circumstances.
So, are an officer's decisions and actions leading up to a use of force considered in determining the reasonableness of the use of force?
They can certainly be relevant, yes.
And did the Supreme Court actually recently speak to whether or not the entire encounter should be reviewed when determining the reasonableness of the use of force?
It did. In, I think, April, the court released an opinion in a case called Barnes v. Felix. So Barnes v. Felix addressed a Fifth Circuit, United States Court of Appeals for the Fifth Circuit rule called the moment of threat doctrine. And in that approach, the Fifth Circuit and one or two other federal circuits looked only at the time the officer used force or the moment immediately before that, right? The time when the officer pulled the trigger or the second or two just before that. The idea was that in the Fourth Amendment context, it was appropriate only to look at the moment of threat. And the Supreme Court reaffirmed its earlier decision in the 1989 case, Graham v. Connor, and said no, in Barnes v. Felix, we do have to look at the totality of the circumstances. We cannot, the court said something like, put on temporal blinders by artificially drawing the line. The court did not identify, in the Fourth Amendment context, the degree to which an officer's actions were dispositive, that is, the degree to which an officer's actions would make a use of force reasonable or unreasonable, but it said pretty clearly, we look at the totality of the circumstances without looking only at the split second in which force is used.
And Professor Stoughton, could you explain your analysis in arriving at your opinion that defendant's decision to draw his firearm and use deadly force instead of removing himself from the vehicle's path of travel was unreasonable and inconsistent with generally accepted police practices?
Sure. So opinion one is really about Officer Grubb's decision to put himself into the position in front of the vehicle. Opinion two is sort of taking as true that he has taken this position in sort of dead center in front of that vehicle. Now what? The idea in police tactics and the use of force is we want to use tactics or force in a way that will address the threat presented by the subject's actions. One way to address that threat is potentially to use force in a way that will remove the subject's ability or opportunity or intention to cause whatever type of harm we're worried about, that is, to take away the threat. Another way to address those situations is to use tactics that can do the same thing. So when we're talking about someone who is in front of a vehicle, stepping out of the path of travel of that vehicle removes not the ability or maybe even the intention, but it certainly removes the opportunity. That is, the vehicle cannot travel sideways. So if you step out of the vehicle's path of travel, there is no more threat anymore. In this case, we see Miss Young sort of turn her steering wheel to the right, sort of just after that where Officer Grubb draws his firearm. At that point, if we're anticipating the potential for there to be a deadly threat, right, for the situation to evolve in a way where there is the ability and opportunity and intention to use the vehicle as a weapon in a way that could inflict serious bodily injury or death, instead of drawing the firearm and standing there, get out of the way. Officer Grubb was in front of the car, by my count, a little over 10 seconds, and more than 4 seconds after drawing his firearm. So there is ample opportunity to, either instead of or in addition to drawing his firearm, get out of the way of the vehicle rather than wait until the vehicle moves forward and then employ deadly force to address that threat.
And Professor Stoughton, in your report, did you do a timing analysis of when exactly the different events took place during the entire interaction?
I did, yes.
Could you describe what we're looking at here in this diagram?
Yes, so this is a timing chart, and all of the times in that second column where it says approximately synchronized video, that is the run time for the approximately synchronized video. That is all 3 videos put together. So I'm identifying specific events using that as the run time instead of the various videos that make up that synchronized video. The event column specifies what happens, and that the second column, approximately synchronized video, identifies when it happens. The next 3 columns are lapsed time, that is how much time has passed. The third column, the one that says lapsed time from previous event, just calculates the amount of time between whatever line it's on and the one immediately before it. So it's just counting up the amount of time between row 1 and 2, between row 2 and 3, not in a cumulative way, just individually. The fourth column, total lapsed time from Officer Grubb stepping in front of the vehicle, starts with event 2. Officer Grubb takes a position near the center of the front bumper and counts the total amount of time that Officer Grubb was in front of the vehicle. The fifth column, total lapsed time from Officer Grubb drawing his firearm, starts about halfway down the row that says Officer Grubb draws his firearm, and then counts the amount of time in those other events from the time when he drew his firearm. That is, how long between he drew his firearm until the time that the shot was actually fired.
And based on your analysis, how much time was it total between when the defendant first situated himself in front of the vehicle to when the shot was fired?
10.467 seconds, almost 10 and a half seconds.
And how much time was it from when Takaya first inched her vehicle forward to when the time that the shot was fired?
So the first inching of the vehicle is about 3.5 seconds. And the way that I'm getting that is I'm looking at Miss Young's vehicle moves forward and then going down to Officer Grubb fired.
And then how much time was it between when the defendant first drew his firearm and when he fired?
4.334 seconds. That's that last number all the way on the bottom right.
And how much time between when Takaya is first seen turning her steering wheel to the right and when he fires?
So that is right about just over 5 seconds, 5.033 seconds. And what I'm doing there is looking at the second column, going to the third number down, 14:10:966, and then going down to 14:16:1.
And Professor Stoughton, based on your timing analysis and your review of the case, what is your opinion?
There was ample time for Officer Grubb to remove himself from the front of that vehicle. Again, even assuming that he put himself there, right, ignoring that piece, there was ample time for him to remove himself from the vehicle, starting at the time he put himself in front of the vehicle, but even looking at when Miss Young rotated the wheel, when Officer Grubb drew his firearm, and sort of subsequent events. There's ample time to take the couple of steps that might have been necessary to get out of the path of travel of that vehicle.
And Professor Stoughton, what is the generally accepted position on shooting at a moving vehicle?
Yeah, so that's a good question. Generally in policing now, officers are instructed to not fire at a moving vehicle when the vehicle itself is the weapon. That is, we're not talking about someone who's shooting from a vehicle. We're talking about the vehicle itself is being used as the weapon in most circumstances. Small caveat, there is developing an exception for when the vehicle is apparently being used as a weapon in a potential mass casualty event, like driving into a crowd or something like that. But outside of that circumstance, officers are generally taught to not shoot at a vehicle when the vehicle itself is the only weapon, because shooting at a vehicle is highly unlikely to actually have the desired effect of addressing the threat presented by the moving vehicle. That is, if you shoot at the driver and miss, or you shoot and just injure the driver now has additional motivation to get the hell out of there. If you shoot and disable the driver of a moving vehicle, that is, let's say you instantly incapacitate them, you've now just created an unguided missile. You haven't stopped the vehicle. There's no way physically for the little tiny mass of a bullet to arrest the momentum of a vehicle. So you haven't actually addressed the threat presented by the moving vehicle, and you may have made the situation dangerous by incapacitating someone who would be able to drive that vehicle.
If a person is right in front of a moving vehicle, is shooting the driver likely to prevent the vehicle from hitting that person?
No.
And does this case illustrate the possibility of then an uncontrolled moving vehicle being the result?
Yeah, the vehicle kept moving after the shooting here. The vehicle kept moving and crashed, and that is the risk, or that is one of the main risks of shooting at a moving vehicle, where, again, if incapacitated, the driver has just lost the ability to avoid, the proverbial lady with the stroller that they would have otherwise avoided.
And is there a concern about how bullets interact with hitting vehicles or the windows of vehicles?
Yes, I mentioned earlier, kind of any object has the potential to throw off bullet trajectories, right, to create ricochets. That's especially well known with auto glass. That's especially true with auto glass. Like, we can't predict with a great deal of precision where bullets that hit glass are going to go.
And Professor Stoughton, is this generally accepted principle that shooting at motor vehicles is rarely effective? Is that frequently reflected in peace officer curriculums?
Yes, training, often in policy statements, yes.
And is there a time, according to generally accepted practice and principles, where it would be deemed reasonable to shoot at a moving vehicle?
Yes, absolutely. So one example would be when it's not the vehicle itself that's being used as the weapon, but instead someone in the vehicle is using a weapon that has to be addressed through the use of deadly force. Someone in the car, for example, is shooting at officers or others. I already mentioned the potential for a vehicle in a mass casualty event. The other possibility is when there is no feasible option to address the threat of being hit by the moving vehicle. And maybe the clearest example of this is an officer who's standing in a narrow alleyway between buildings and the vehicle is coming at them. There is no opportunity, I should say that differently. There is no chance for the officer to reposition in a way that deprives the person of the opportunity to hit them, right? They remain vulnerable to being hit. In that situation, shooting the vehicle is still not likely to actually stop the vehicle. It's still not likely to be effective, but it's the best option that we have under the circumstances. So it's not likely to be effective, but it is more likely to be effective than doing nothing at all. So in that sort of limited situation, and the way that we see this in most policy guidance is directives for officers to not shoot at moving vehicles unless there is no feasible alternative to doing so, no way to get out of in front of the vehicle.
I have no further questions. Thank you, Your Honor.
Ladies and gentlemen, we're going to take a 5 to 10 minute break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or your presence. It is your duty not to form or express an opinion on the case until it's finally submitted.
All rise.
cross-examination.
Thank you, Your Honor. May I proceed?
Okay.
Mr. Stoughton, I want to start off where Mr. Glennon left off. May I have the computer, Ms. Cook? Your second opinion there, the one that talks about instead of removing himself from the vehicle's path of travel, you indicated to the ladies and gentlemen of the jury that that was the preferred tactic, that was the better, reasonable tactic in order for Connor to avoid being hit by the car, correct?
Yes.
Okay. Now, sir, you remember back in 2024 and 2025 when I sent you the seminal case here in the state of Ohio called State versus White, correct?
Yes.
Okay. And you would recognize that decision if I sent it, or if I showed it to you in court today, right?
Sure.
May I approach the witness, Your Honor?
Okay.
Sir, this is the decision of State versus White that I've sent you, correct?
Yes.
May I have it back?
Yes.
Thank you so much. May I have the Elmo, Your Honor?
You can speak to Ms. Cook about that.
Oh, I apologize. Thank you, Ms. Cook. Okay. So, as you stated, this is the law here in the state of Ohio, right?
Yes.
And did you review this before coming in to testify to court today?
I have reviewed it a couple of times. I'm not here to apply Ohio state law,
I'm
so
not asking that.
specifically for this.
So you didn't review this?
That's not what I said.
Okay, I apologize. I must have misheard you.
I have reviewed it a couple of times,
Okay.
not specifically for this.
Okay, so you've reviewed it a couple of times, but just not for this case.
Yes.
Okay. Can you read this head note for us, sir, starting with, actually just read the whole entire head note. Starting with Graham's prohibition.
Sure. So head note 17, law enforcement officials, excessive force. Graham's prohibition from using the 2020 vision of hindsight extends to the testimony of even most the erudite police procedure consultant when it crosses into the prohibited territory of second guessing and armchair reflection. This includes comparative speculation, couched in backward-looking terms, about what an officer could have done or might have done differently, or whether he should have employed alternate or lesser means of force or different tactics.
Thank you, Professor. It says, or different tactics, correct?
Yes.
Now, redirecting you back to the computer with back to your opinion. Your second opinion is that he should have used a different tactic to get out of the way of the vehicle. That's what you just testified on direct examination to these ladies and gentlemen of the jury, right?
Yes.
But
That his tactic of remaining in front of the vehicle and drawing his firearm was professionally inappropriate. Yes.
But the law says that what an officer could have done, might have done, or whether he should have employed different tactics is comparative speculation. That's what the quote that you just read to the ladies and gentlemen of the jury said.
Sure, and I will leave it gracefully to the judge to instruct the jury on what the law is. I'm not here to apply Ohio state law. I'm not an expert in Ohio state law. I'm an expert in generally accepted police practices. To the extent that Ohio state law differs from my focus as a policing expert, that's kind of up to somebody else to figure out, not me.
Sir, you testified on direct examination, though, that generally accepted police practices certainly come from state law, correct?
I would say that they are typically informed by a combination of law. My specific testimony was about Fourth Amendment law, but state law should also inform generally accepted practices in that jurisdiction.
And so you're an expert here in the state of Ohio, and you don't know what the state of Ohio's laws say?
That's not what I said.
I'm asking.
About what?
About looking backwards, about using hindsight in order to determine if an officer should or should not use a different tactic.
Yes.
Okay.
I'm familiar with the case and just read a head note, which of course is not the text of the case, it's the head note.
Do you need some time to read the entirety of the case, sir?
No.
Okay. Thank you. Now, you're not a practicing lawyer, correct?
That's correct.
A practicing
Well, that's a necessary prerequisite. I've done that.
Okay. But you choose not to practice. You're in academia.
Correct.
Okay. Now, either way, you've certainly spent a lot of time in the courtroom before, right?
Sure, I think that might depend on how we define a lot, but sure.
You've testified in over 15 cases, I think you said on direct examination, 18 to 22 cases.
Yeah, something like that, plus more in depositions and the like, yes.
So you've been in the courtroom a lot, right?
Yeah, sure.
Okay. And based on your experience of being in the courtroom, you know it's my job as the practicing lawyer to ask questions, right?
Yes.
And it's your job as a paid opinion witness to answer those questions. True?
As a witness generally, sure.
Sure. Now, if I ask a question that you don't understand, do you promise to let me know so I may ask a better, more clear question?
Sure.
Thank you so much. And do you agree to answer my questions in the way that I ask them, rather than another question that's not being asked?
I'm sorry. If you're asking me if I can answer your questions, sure. If I understand the question, I will answer the question that I understand you to be asking.
Sure, and if you don't understand, you'll let me know.
Yes.
And you'll answer the question as I pose it to you, yes?
Sure, unless the answer would be manifestly misleading of some part of my testimony or opinions.
Sure, you can answer my questions though, yes?
I hope so.
I hope so too, sir. And if you answer a question I didn't ask you, that will force me to re-ask you the original question, and that would waste everyone's time, won't it?
Probably.
So if I asked you what state you're in today as you're sitting here testifying about what a police officer did here in this state, how would you answer that?
I am currently in the state of Ohio.
Thank you, sir. Now, you kind of went over this on direct examination about you being paid to offer an opinion, correct?
I'm compensated for my time. I'm not paid for my opinions.
Well, certainly fair to say that if you didn't give these guys the opinion that they wanted, you wouldn't be on the stand testifying?
Yeah, that's probably correct.
Okay, so you gave them the opinion that they wanted, and now you're here testifying.
No. I gave them the opinion that my review led to. The fact that it's helpful to them is irrelevant to me.
Okay. So fair to say that prosecutors work for the taxpayers?
Sure.
And you were
I would
hired?
I would say broader than just taxpayers, right? They work for the public generally, regardless of whether they're taxpayers or not.
Sure, but certainly taxpayers are included in that.
Yeah.
Okay. And you were hired by the prosecution, right?
Yes.
Okay, so taxpayers fund the state of Ohio's budget, yes?
Yes.
And so you would agree with me then that the taxpayers are paying you $415 an hour to evaluate this case, yes?
Sure. Through an attenuated series, sure.
Okay. And I think you testified on direct examination, you believe you've spent maybe 30 to 35 hours that you have billed the state of Ohio?
I think that's right. I'd have to look at the invoices on this case to confirm that, but I think that's about right.
It's just an estimate, 30 to 35 hours?
Yeah, probably something in there.
Okay. So at 30 hours and $415 an hour, the conservative estimate is you've billed about $12,450 to date, yes?
Sure. That sounds about right
Okay,
mathematically.
And if it were 35 hours, you would have billed $14,525.
I cannot do that math in my head, but sure, that sounds about right.
Okay. And you're testifying today, you've been on the stand for over 2 hours, but you billed for 8 hours of testimony no matter how long you're on the stand. Is that correct?
I bill at a minimum rate of 8 hours on days of testimony. Today I'll be traveling as well, so it'll be more than 8 hours today between testimony, the actual hours of testimony and travel.
Okay, so more than 8 hours. About how many do you think you'll bill for today?
I don't know. It depends on when we end and how much downtime I have between like getting to the airport and getting home.
That makes sense. But let's just call it 8 hours for conservative purposes, knowing
Sure.
that you're going to bill more than that. So that's an additional $3,320, true?
Yes, plus travel yesterday.
Thank you. And all of us think about work while we're doing other things like doing laundry or driving. Would you agree with that?
I try really hard not to think about work when I'm doing other things.
That's fair. Me too. But certainly it creeps in, right?
It can.
Do you think that you probably have spent time that you haven't billed for, in addition to the time that you have billed for thinking about this case?
Sure. I'm sure there were like short phone conversations here or there, or like things like that, where it wasn't just thinking about the case, it was like actually working that I just don't bother to bill because it's not worth it.
So fair to say total at the end of all of this, you'll probably have put at least probably close to 40 hours into this case?
Sure, that seems fair.
And while you were preparing your report to form your opinion, how many different angles of the incident did you review?
So there are 3 different cameras of the incident itself that best capture the incident. There are more security cameras from Kroger that informed the angles, but not to the degree that they actually captured a lot of relevant information.
Did you review that camera though also?
Yeah, I reviewed all of the videos that I
Okay.
have.
So you would agree with me then you've at least reviewed 4 angles. The RX video walk-up,
Yep,
the Kroger security camera footage,
the outside one, yes.
Grubb's body-worn camera,
Oh, yes,
and Moynihan's body-worn camera.
yes.
So you reviewed 4 different angles before coming to your conclusion, correct?
At least that. I think there were actually more, but it's at least that many, yes.
Now, you know a lot about body-worn cameras, right?
Yes.
And you would agree with me when I say that these cameras can sometimes be outright misleading, yes?
Absolutely.
Now, it's possible, sir, that some opinion witnesses in court cases bring biases with them into their work, right?
Sure.
In fact, you would agree with me that certainly everyone has certain biases that color their interpretation of the world around them. True?
Sure. That is the nature of the human experience and cognitive bias, yes.
And an opinion witness with a very strong bias could use his platform to unfairly affect a jury. You would agree with that, right?
So, no, I think you're confusing their bias and advocacy. You can separate those. A witness who's biased may affect their conclusions. Regardless of bias, a witness could inappropriately engage in advocacy, but those 2 things aren't necessarily related.
So is it your testimony today that a very strong biased opinion witness could not use his platform to attempt to unfairly affect a jury?
No, I just think those are separate things. Like, that doesn't have to be the result of bias.
Okay, so that's not my question. I'm asking you particularly with respect to bias. Do you think that opinion witnesses can come in here and unfairly affect a jury with their biases?
Can you define what you mean by unfairly, right? Because the point of the adversarial system and a judge's instructions or limitations should address that unfairly point.
Correct.
If a trial is being well managed, then no, it wouldn't be unfair. It would be within the scope of a trial. If it's not, then sure, I suppose that could be unfair in some way, but it might depend on what you mean by unfair.
You're aware that the judge is going to give this jury an instruction saying, do not let your biases creep into the back of the jury room.
I am not going to presume to guess anything about the judge's instructions to the jury, but that would be a pretty standard instruction.
You would agree with that, right?
Yes.
And so if a witness comes in here with bias, you're saying that that bias can't somehow bleed into the jury deliberating.
No, I guess I'm confused when you're focusing on unfair bias, right? The point of the adversarial system is to address the limits of unfair bias and to prevent a witness's, let's say, unfair statements, right, from being considered or adopted into the jury room.
And our statements, or our system is perfect?
Hardly that.
Okay, so it's possible then that biases could affect what is presented on the witness stand, correct?
Oh, sure, yeah, I agree with that.
Thank you. Now, do you have a copy of your CV up there, just in case?
I do not.
Okay. Would you like a copy of your CV? Because we're going to talk about the cases that you've testified in at trial.
Sure.
May I approach the witness, Your Honor? This is a copy of your CV, Mr. Stoughton. I tabbed in green where you start with your case citations.
Okay.
Okay? So, I'll let you get there. So
All right.
for police use of force cases, where you've actually testified and given trial testimony, like you are doing today,
Sure.
let's start naming the cases in which you've given an opinion that stated that the police officer's actions were contrary to generally accepted police practices. Go ahead.
In trial testimony.
Yes, sir, in trial testimony.
Okay. So the first one, this is an older version of my CV. The first one is People v. Sean Grayson.
You said Grayson?
Grayson, yes. Grayson.
Okay.
Trial testimony.
Yes, sir.
The Christian Glass case in Colorado.
What others?
I'm sorry?
I'm sorry, I said what others?
Taylor in Texas. Meade. Nigro, Nigro. Glass on the civil side. Herndon, Herndon. Schurr, Schurr. Potter. Chauvin. Coy. Jones. Rhines, Rhines. Rhines. Smith. Calmer, Calmer.
And that's one where the defendant shot and killed 2 police officers, true?
No, he shot and killed one officer.
Okay, but he shot at 2 police officers?
I don't know. There were 2 police officers there. I don't think he shot at more than the one.
Okay, so he killed a police officer?
He did.
Okay.
That's what I have.
What about Grayson, sir?
That's the top one on there.
Oh, I apologize. I'm so sorry. Let me see here. Norton? Did you testify in the Norton case?
I did, not with an opinion finding fault with the officers, which is what you asked about.
Okay. So, these are all the opinions that you've testified in court at finding fault with the officer, true?
No, I understood your question to be, these are the cases in which I've testified at trial, in which I've had an opinion finding fault with the officers.
That's correct, sir. That's
Yes,
what I asked.
yes.
Okay, so how many, going through your CV, have you testified in trial, given trial testimony, that you found not at fault with the officers?
Almost all of those cases also have opinions where the officers did things appropriately.
Sir, I'm talking about your overall general opinion. When have you testified in trial on behalf of a police officer?
You mean without finding any fault at all with the police officer?
Sir, that the police officer hired you
Oh, well,
in trial.
okay, so you're asking about cases where I've been retained by whoever is representing the officer, and I've testified in trial without any opinions negative to the officer? Is that what you're asking?
Yes.
That's a series of limiting considerations. Let's see. I don't think all of those conditions have lined up. I don't think I've done any cases where all of those things are true and nothing else.
Thank you, sir. Now, you teach law students, true?
Yes.
Are you aware of a national website called Rate My Professor?
I have heard of it.
Okay. And these law students that you teach, oh dear. There we go. These law students that you teach certainly spend a ton of time with you, true?
Your Honor, I would object at this point. The state hasn't seen this, isn't familiar with it.
Yes, my students spend probably more time than they want with me.
How many credit hours do you teach?
I have criminal law is 3 credits this semester, criminal procedure is 3 credits, my police law and policy class is 3 credits. Regulation advice students can take as either 2 or 3 credits. I also supervise supervise legal research projects.
And so for the credits that they spend, they have to spend X amount of hours, or in order to achieve those credits, they have to spend X amount of hours with you. You would agree with that, right?
Yeah, I think the ABA actually regulates by minute, but yes.
Would you be surprised that at least one of your law students believes that you're not an expert in police self-defense?
I would be surprised if we could identify that anyone who rated me on Rate My Professors is one of my students. There's no verification.
Well, actually, so there is a verification. Are you aware of that verification process?
I am yes, in some sense, but no,
Okay.
not specifically.
That's fine. One of your students here says, it's difficult to understand how someone who had only worked as a police officer for 5 years could be considered an expert in the area. As the saying goes, those who can do, those who teach can't. That's true, right?
Which part?
That's what it says, yes?
Yeah, that's what it says. I don't know what SCHC 388 is. That's not a class I teach.
So that's not what I asked you. That's what
That is what, yes, that is what someone's anonymous comment says on the internet, yes.
Okay. Well, it certainly says that you worked for a police officer for 5 years, right?
Sure.
That's an intimate detail about you, true?
No, that's widely available on like the internet all over the place,
Okay, so,
including on my faculty bio. I don't talk about that in class.
okay, you don't talk about that in class.
No.
Okay, that's fair. Let's see here. Professor Stoughton is a politically charged narcissist. That's what this review says. True?
Your Honor, I would object again. These are just random comments found on the internet by unidentified people. This is not appropriate.
Overruled. Cross-examination.
Thank you, Your Honor. That's what that says?
That is what it says. And Laws 672 is a class that I teach,
Okay.
I think.
All right, this next one says, made memes of himself to try to appear hip, shoehorns his personal politics into every discussion. Very unprofessional, right?
That's what it says. I can tell you I have never made a meme of myself, although sometimes students will make memes of me and pass it around.
And this says it was reviewed April 12th of 2021, right?
That's when it was submitted, yes. So that's, it also says A+, and that's not a grade that we can assign at my school. So I don't know who's, like, that's just not accurate.
Again, sir, I'm not asking you who wrote this review or anything like
That's
that. I'm just
good,
asking
I have no
you.
idea.
I'm sorry?
That's good, I have no idea who wrote
Okay,
it.
yeah, all I'm asking you is that certainly this is on, is a publicly available website, and it's got this review of you that says you shoehorn your personal politics into every discussion, correct?
It does. Other aspects of that make me think that I haven't had a discussion with that person, since it says no textbook, and my classes involve textbooks. It says A+, and that's not a grade that I give. It says not mandatory for attendance, and all of my classes are mandatory attendance.
That's right. So some internet troll just got on the internet then and just decided to destroy your reputation here.
I mean, if you look at the timing, this is around the time of the Chauvin trial. That may very well be the case.
Okay. Now, thank you, Ms. Cook. You live in South Carolina,
I do.
and more than 20 years ago, you were a police officer in Florida.
Correct.
But you're here today to talk about what a police officer did here in the state of Ohio, true?
Yes.
And as a paid opinion witness, you've already admitted to the ladies and gentlemen of the jury that you don't know a lot about Ohio law, right?
So having nothing to do with being compensated for my time, I do not apply Ohio law when I'm here as an expert to talk about generally accepted police practices.
You realize that police enforce the law, right?
Yes.
Okay, so, and you're testifying here today, again, as a paid opinion witness on behalf of these prosecutors, but you didn't review any Ohio law before coming into court to testify.
I'm not answering legal questions with my testimony, so no, it would be inappropriate for me, like it would be for any witness, to offer a legal conclusion.
I'm not asking you for a legal conclusion, sir. Is there a reason why you don't want these members of the jury to know the answer to my question?
I think I'm answering your question.
I don't.
It would be irrelevant for me to review Ohio law because I'm not offering an opinion that backs itself or grounds itself in Ohio law. I'm applying generally accepted police practices. It would be a little bit like, did I review a cookbook? No, because that's irrelevant to the opinion that I'm actually generating. Now, Ohio law is clearly relevant to what the jurors are being asked to do, but I am not a juror applying Ohio law to the facts of this case.
Connor Grubb has to enforce Ohio law, sir, correct?
Sure.
Okay, and you didn't review that Ohio law before coming into court to testify today, yes or no?
That's correct,
Okay.
because it wouldn't matter to my opinion.
Thank you so much, sir, for telling me that Ohio law doesn't matter to your opinion. I appreciate that.
Sure.
Now, you don't know what Ohio law says about when a police officer can use deadly force?
I'm sure I do. I've written about it elsewhere. It's just not relevant to my opinion in this case.
Can you name the Ohio Revised Code section that permits officers to use self-defense here in the state?
Do you mind if I refresh my memory?
Not at all. Take your time.
Also, I need reading glasses. My eyes just realized they were in their 40s.
I have readers back in my office.
I didn't expect to need to read. Boy, they print these books really tiny. So we have a table of cases and state statutes in the opinion, in the book. One of the chapters is about the state law standard. I'm sure I don't know what it is offhand, but I'm sure I looked at Ohio law at the time, because I looked at the law in every state at the time for writing the state law chapter.
I was talking about before testifying today.
Yeah, I wrote the book before testifying today.
You wrote the book when? What year?
I wrote the book starting in probably 2017, 2018. It came out in 2020.
It's 2025 now?
It is.
You were never certified as a police officer here in this state, correct?
That's correct.
Your police training from near a quarter of a century ago is certainly not the same as the police training that Connor would have received more recently.
Boy, I hope not.
On direct examination, you talked about your education and experience, true?
Yes.
Your undergraduate degree wasn't in criminal law, wasn't in pre-law, wasn't in criminal justice, it was in English literature, true?
Yes.
And before you even finished college, you said you spent a few years as a full-time officer in Florida?
I'm sorry, ask that again?
Before you finished college,
Yes.
you spent a few years as a full-time officer in the state of Florida, correct?
Yes.
You said under 5 years?
I was full-time for about a little over 4.5 years, and then part-time for another 6 months, so yes.
And in those 4.5 years, you never worked for internal investigations, correct?
No, I did that when I left and went to a state office.
You never were promoted to sergeant,
No.
definitely never promoted to a lieutenant.
No, certainly not.
You chose to leave police work again for academia, true?
No, I left police work to go to law school and then eventually made my way into academia.
Sure.
Yes.
Thank you. Now, you testified at grand jury in this case, correct?
Yes.
Now, as a law professor, you're aware that in the grand jury, there are no rules, true?
I wouldn't say there are no rules, but I would say that it's a very different set of rules than applies in trial.
Well, there's no judge, right?
Correct.
There's no me or Mr. Collins as defense attorneys, true?
Yes, that's correct.
There's no rules of evidence that applies, true?
Broadly, yes.
Okay. This case had to be presented to the grand jury before an indictment came out, right?
Yeah, the grand jury is the one that indicts, so yes.
Correct. And not just anybody can show up and say, hey, I've got some information for the grand jury. Can I testify,
Your Honor, I
right?
would object again. They shouldn't consider the indictment for any purpose.
Councilwoman approach.
Thank you, Your Honor. Sorry, sir, I was saying, so nobody can just show up to the grand jury and say, hey, I've got some information for you, let me testify, right?
Do you mean the prosecutors call the grand jury witnesses? I'm not sure what you're asking.
Any random citizen can't show up to the grand jury and say, hey, I've got some information I would like to testify right here, right now at the grand jury.
I mean, they can approach the prosecutor and say that. Whether or not they get to is up to the prosecutor to call them as a witness.
Sure, it's up to these guys who to call as a witness at the grand jury, right?
Mhm.
Just like it's up to them.
Sorry, yes.
Just like it's up to them who they get to call during their case in chief, true?
Yes.
Okay. You would agree with me that you were called to testify by these prosecutors at the grand jury, yes?
Yes.
And you were retained by these prosecutors on April 29th, 2024, correct?
I'd have to go back and check the date, but I think that's right.
I can get the date for you, sir. Do you remember testifying at the Daubert hearing?
I do. I just don't remember the specific date, but I'm happy to accept your representation that that was the date of retention.
Appreciate that. So that's April 29th, 2024, true?
Sure.
Are you aware of when this case was indicted?
No, I don't remember.
You don't remember us talking about it at the Daubert hearing either?
Not offhand.
Okay. So if I told you, would you accept my representation that it was not indicted until August 13th of 2024?
Sure.
Okay, so you were retained by them though in April, right?
Yes.
And you testified at the grand jury before the charges came out here, true?
Yes.
Your report was dated July 31st, 2025, correct?
Yes.
Now, when you testify or write reports as an opinion witness, you testified on direct examination that the term of art that you choose to use is officer-created jeopardy, true?
As a way of referring to unjustified risk-taking, yes. I use a couple of phrases. That is one of them. Sometimes I just use the phrase, as is mentioned in this report, unjustified risk-taking, unsound tactics. The point is similar with all of those.
I'm talking about just in your conclusion, though, you only use your term, officer-created jeopardy, true?
I mean,
your
in opinion one,
Yes, sir.
I mean, I describe it as unreasonable, as contrary to generally accepted police practices, as officer-created jeopardy, and as foreseeably contributing to the shooting.
Sure. Can we just pull the computer up? I'll pull the slide up for you.
Sure.
Where it says officer-created jeopardy. That's the term of art that I'm focused on for the line of this questioning, okay?
Sure, yes. I also use that term, yes.
Okay. You see where it's highlighted in yellow?
Yes.
Constituted officer-created jeopardy. True?
Yes.
Okay. Now you're aware that the Supreme Court of the United States has held on the use of deadly force, has listened to a couple different cases, true?
Yes, a number, yes.
Okay. Tennessee versus Garner is one.
Sure.
Graham versus Connor is the other.
It is another, yes.
Scott versus Harris is another. True?
Yes.
Now, you testified about how the case of Tennessee versus Garner, the facts of that case. Do you remember that?
Yes.
About shooting a fleeing felon. True?
Yes.
Okay. But the facts of that case certainly don't mirror the facts of this case, correct?
Yes.
Okay. You would agree with me that Connor Grubb got hit by a car, correct?
I have no opinion as to whether he got hit or not hit by a car. He was certainly in front of the car when it started moving.
Sir, you can see on the video that he gets hit by a car, no?
I can't see on the video a point of impact. I'm not saying he didn't get hit. I'm just saying I can't testify to my degree of expert certainty in my area that he was struck by the car. Was there contact? Absolutely there was contact. He put his hand on the car, among other things. But I don't know whether he was impacted or hit.
I'm just asking you to use your eyes, sir. I'm not asking for any expertise or anything like that about generally accepted police practices. Just watching the video, you're telling these ladies and gentlemen of the jury here that Connor Grubb did not get hit by a vehicle?
If you're asking for a lay interpretation of the video, that's up to the jury. I testify as an expert. So to a degree of expert certainty, I can't define that he was hit or not hit. That's also not really the point of any of my opinions.
Sir, I get to ask the questions. Remember, we established that on direct examination, right?
On cross.
Examination, yes. And is there a reason why you don't want the members of the jury to know what it is that you see on the video, whether or not Officer Grubb gets hit by a vehicle?
I am happy to talk about that.
I would just like
But the jury gets to decide what the facts are, not me.
Did you review the video?
Yes.
Did you see him get hit by a car?
I did not see a point of impact. I saw his hand on the car. I saw what looks like plausible contact. I have reports that say that he was hit by the car. I have at least some evidence suggesting not. It's not the job of an expert to resolve factual disputes.
Sir,
So-
that wasn't my question about what the job of an expert is. I'd really like you to stop wasting time and just answer the question that I asked you.
You're asking a question that is outside the scope of my expertise.
You can't use your eyes?
Sure, I can watch the video and I can tell you I don't know from the video, having watched it a great many times, whether Officer Grubb got hit by the car or not. I see his hand on the car. I see what plausibly could be contact between the car and his leg. I also see what plausibly isn't necessarily. I don't know, and I'm not going to testify to a reasonable degree of professional certainty, since I'm here as an expert, about what happened when I don't have a good basis for it.
Not what I'm asking you again, sir. All I want to know is, did you see Connor Grubb get hit by the car? Yes or
Your
no?
Honor, he's answered the question at this point.
Counsel Approach.
Now, you've never been a judge, have you?
No.
Certainly never a Supreme Court justice, right?
No.
Judges shape the law. You would agree with that, right?
Sure.
You went to law school, though, so you would agree with me that when the Supreme Court makes a ruling, every court in the country must follow that ruling, true?
It depends on the nature of the ruling. If the court is making a ruling and it's exercising its administrative power over the federal courts, no, it wouldn't apply to state courts. If it's a constitutional ruling, yes.
Okay, so as long as it's applicable, when the Supreme Court speaks, the states follow.
Yes.
Ohio courts have to follow it, true, too?
Sure. Anything that is applicable to constitutional rights or the like, yes.
Even the judge in this case, if the Supreme Court makes a ruling that's relevant to this case, this judge has to follow that, true?
Sure. If there's a relevant ruling, yes.
Mandatory directives from courts are very serious things, right?
Sorry, say that again. Mandatory directives from courts, like injunctions?
Mandatory directives like the law. When the Supreme Court articulates the law, that's serious, true?
Sure.
You would agree with me that the U.S. Supreme Court in Graham versus Connor said evaluate an officer's use of deadly force, people like you and the jury must not use hindsight 2020. True?
Yes, I think they say avoid the 2020 vision of hindsight.
Thank you. Now, you would agree with me that it's this judge's job to give the law to the jury, yes?
Yes.
And whatever is in those jury instructions, this jury must follow.
I really don't want to get into any position of instructing the jury, but yes, the jury should follow the jury instructions.
Thank you. Now, I've actually sent you a couple different sets of jury instructions that we've used over the past couple times you've testified, yes?
In previous cases?
Yes, sir. You don't remember receiving an email from me with prior jury instructions from this court?
Which case was that in?
The Meade case, the Coy case. I've sent you Mitchell jury instructions before. I've got the email if you would like to see it.
Yeah, yes, it sounds familiar.
Okay. Now, nowhere in any of these U.S. Supreme Court cases does it mention your term of art, officer created jeopardy, correct?
Those cases do not use that exact phrase.
And in the jury instructions, nowhere in the jury instructions that I have sent you from prior cases does it mention the term of art, officer created jeopardy, correct?
Sure, the jury instructions do not use that exact phrase.
And actually in OPATA, the training materials that you reviewed, nowhere in those training materials does it use the words officer created jeopardy, correct?
Right, it certainly reflects the concept, but it does not use that particular phrase, yes.
And you also testified in another case as an opinion witness. Do you remember the Taylor v. Holtmeyer case?
I do. I think that was limited to deposition testimony.
Okay. And that court was a federal court, true?
Yes.
And that court held that your opinion regarding the use of deadly force is inconsistent with the Supreme Court's opinion in Scott versus Harris, correct?
Sure.
Now, I want to talk to you about your report, and actually testified to this on direct examination. You stated, it is well known and generally accepted that time is the single most important tactical concept in policing, true?
Yes.
Okay. Now, you say that time is the most important tactical concept, so you're talking about the present tense, yes?
Yeah.
You're not talking about from a quarter of a century ago when you were a police officer.
Then too.
But you're certainly talking right now, true?
Yes.
As you sit here today, you believe time is the most tactical, important policing concept, yes?
I think, sure, today, yes, absolutely. I don't think it's just today, right? I think it's actually a very old observation.
I understand. So did you take a poll of all police officers in America to determine that this notion is well known?
No, I reviewed training material, use of force policies, tactical guidance, tactical training manuals going back to the 1970s.
So no, you didn't take a poll.
I did not take a poll.
And did you take a poll of all police in America to determine that this notion is generally accepted?
I did not poll. No, this is not survey research.
Okay. So you have a footnote citation there, true?
Yes, that's a citation to my book.
Your book.
Yes.
Not all of these 1970 policies or anything else you just told the ladies and gentlemen of the jury about. You cite to yourself, true?
Well, those are cited in my book.
So that's not what I asked. You cite to yourself, correct?
Yes.
Okay.
I cite to myself because the book consolidates, as books do, a bunch of information from other sources. Like, I think I have 563 footnotes in the book, including those relating to what I talk about in a more concise way, and then cite to my book, because I think I said it better than the other folks did.
Certainly here you cite to yourself, true?
Yes.
That's your own opinion, right?
No, that's not my own opinion. That's reflected from the information gathered for the book.
The book doesn't have your opinion in the book, sir?
It has some opinions of mine in the book. This is not what I would describe as an opinion.
Okay. Your book is not your opinion.
It's not what I said.
Okay. I'm asking.
The book has things reflected in it about generally accepted practices that I don't agree with, that are not my opinion. The book has things that do reflect my opinions or that align with my opinions, particularly the conclusion when my co-authors and I offer some specific suggestions. That's definitely opinion. But for example, the chapter on constitutional law or state law, no, that's not my opinions. That's just what it is. That's about the state of the world.
Again, sir, redirecting you back to my question, I really appreciate that very long narrative that you just gave the members of the jury. But redirecting you back to my question, that footnote cites yourself. Yes or no?
It does. I'm sorry. I thought your question was, does my book have my opinions in it?
Thank you. I appreciate that. Turning to page 39 of your report, you claim that it is well known and generally accepted in policing that officers should avoid putting themselves into a vehicle's path of travel. You would agree with that, right?
Yes.
That's what you write it in your book, or I'm sorry, in your report, true?
Yes.
And you established you didn't take a poll on Pleas to see if it was really generally accepted or well known, right?
Right. Yeah. That's survey research is not how one develops that. But yes, that's correct. There is no survey research underlying that.
And in fact, there's no citation here at all. True?
Right, because that's an introductory sentence to the rest of the paragraph that has a bunch of cites in support of that particular point.
Sir, that's a whole entire sentence equipped with a capital letter and a period, right?
It is introducing a whole entire paragraph with a number of sentences on that topic.
And that sentence does not have a citation. True or not true?
That sentence does not have a citation.
Okay,
Yes.
Now, that's an important statement. True?
The what's highlighted there?
Yes.
Sure. Like I spend multiple paragraphs on that point.
Okay. Now, you testified on direct examination about the IACP law enforcement policy, correct?
Yes, that's the International Association of Chiefs of Police model policy or consensus paper. I have a couple of different things from IACP that I cite in my report.
In those sentences thereafter, this one with no footnote cites the IACP model policy for vehicles, true?
One of them does, yes.
Okay. May I approach the witness, Your Honor?
Okay.
This is that model policy that you cite in your report, correct?
Yes, that's it.
May I have the Elmo, Miss Cook? Now, on page 3 of that policy, this says right here, this document is not intended to be a national standard. True or not true?
Yeah, that's what it says.
That it's not meant to be a national standard.
Sure.
Now, you would agree with me, sir, that generally accepted police practices say that an officer can use force when there is an imminent threat to something that the officer is lawfully trying to do. Yes or no?
Sure.
May I have a moment? Thank you, Mr. Stoughton. I have no further questions for you at this time.
Councilman approach? Everybody, join the party. Is everyone okay with redirect?
Thank you, Your Honor. May I proceed, Your Honor?
Yes.
Professor Stoughton, you were asked about that sentence in your report. It is well known and generally accepted in policing that officers should avoid putting themselves into a vehicle's path of travel. Indeed, stepping into a path of travel of the subject's vehicle is perhaps the paradigmatic example of officer-created jeopardy, having been used as an illustration in. And then right after the defense attorney cut it off, did you actually then go on to provide multiple citations?
Yes, there are 1, 2, 3, 4, 5, 6, 7, 8, 9. Yeah, like that discussion goes on for the next page and a half.
So, right, after you say it's perhaps the paradigmatic example of officer-created jeopardy, where does your report go from there?
It talks about that as an example of officer-created jeopardy, again, just unjustified risk-taking, being used as an example in books. I think that's a cite to the way that we use it in the book. Book chapters, training presentations. It talks about the International Association, bad capitalization on my part, the motor vehicle policy, which states in relevant part, quote, at no time should the officer or others stand in front of, between, or behind the stopped vehicles. It talks about these articles from 2005 in Police magazine in 2006 that describe stepping in front of a vehicle or stepping into a vehicle's path of travel as a very poor tactic, placing the officer in a position where, if the driver attempts to escape, the officer may interpret it as an attack and shoot. The block quote at the bottom there, and that I think feeds over to the top of the next page, is actually from a 2025 article after the date of this incident, reflecting on the long-standing nature of this particular aspect of policing. In the block quote there, the author is reflecting on, when I was an officer, it was unthinkable to step in front of the suspect's vehicle in order to order them to stop, I do not know when this dangerous tactic began, but it is an ill-advised tactic. It is not an acceptable police procedure. This tactic is another example of officer-created jeopardy because it puts the officer in the zone of extreme danger. That's from a 2025 article in Police magazine.
So did you actually cite fairly extensively after your assertion that it's well known and generally accepted that an officer should not place himself in front of a vehicle's path of travel?
Sure, that's how paragraphs work, right? You introduce the paragraph with a sentence that tells you what that paragraph's about. You then write some sentences that support what that paragraph's about with citations as appropriate.
And now, there's been lots of talk about this officer-created jeopardy. Is there a preoccupation with just the specific terms, officer-created jeopardy, those words?
Yeah, there seems to be a lot of focus on the magic words officer-created jeopardy, which are utterly irrelevant, right? Again, it's the concept of unjustified risk-taking that is important, in the same way that when some police agencies refer to the backdrop of a shooting and other police agencies refer to the backstop of a shooting, it's not the disagreement in terminology that's relevant, it's the concept that both of those terms are being used to address. So whether we talk about unsound tactics or we're even more verbose and say unsound tactics that foreseeably increase the likelihood that officers will be exposed to danger that sound tactics would have avoided and thus have to use force, or whether we just summarize that as unjustified risk-taking or officer-created jeopardy, shouldn't really matter.
And if not the words officer-created jeopardy, are there tactics and concepts throughout the basic training curriculum of peace officers that deal with officer-created jeopardy?
Sure, if we didn't care about unjustified risk-taking, we wouldn't have tactical training at all. Right? We wouldn't tell officers this is the safest way to address a particular situation, or this is a reasonable scope of safe options to address a particular situation, because we wouldn't care about whether the risks they take are appropriate. But we do. That's why we have tactics.
And I know that it's not your job to instruct the juries on the law that they are to apply, but it was asked about, had you received jury instructions from a defense attorney, and do you see anywhere the words officer-created jeopardy? Did you see, while those words might not be there, would the words totality of the circumstances be there?
I would have to look back specifically at them. I think so, but I would have to look back specifically at what they were.
And if they did include the words totality of the circumstances, would that include the decision-making and the actions of the officer
earlier in the encounter leading up to the shooting?
I mean, I think that's part of what it means to be totality of the circumstances instead of taking a moment of the threat or a final frame approach.
And now, Professor Stoughton, do you, in your role as an academic, well, I guess they've asked about 5.5 years as a police officer. You were a police officer for 5.5 years, correct?
Yeah, thereabouts, yes.
And have you devoted your academic career to primarily the study of policing?
Yes, exclusively the study of policing. I've been a policing scholar now for 13 years, and that's really the only thing I research is policing.
And are you still active in the actual world of policing beyond academia?
Yeah, very much so. I run a program that provides police training at the officer level and at the executive level around South Carolina and around the country. I actively speak to police audiences all the time. I work with agencies all the time. So yes, I try to take myself out of the ivory tower to the extent that I can.
And in your role as a scholar, as an academic, will you discuss or publish on ideas for what you think would be better officer practices, or even practices that are considered acceptable that you don't agree with?
Sure, yeah. Part of my work as an academic is to identify promising best practices, to identify whether there's empirical research supporting that or not. The National Institutes of Science commissioned me and several co-authors to write a paper on the empirical evidence that we have about use of force, right? That is, what affects officer use of force. Yes, as an academic working in the area, I certainly look for and attempt to promote best practices. But there's a significant difference between my role as an academic and my role as an expert, and the promotion of best practices or cutting edge practices and looking at generally accepted practices which are really beyond reasonable dispute.
And do you keep those roles distinct when you're asked to review a case to provide expert analysis as to whether an officer's actions were reasonable in terms of generally accepted practices and principles?
Extremely distinct. The way that I sort of analogize it is like the rules for my kids at my house as opposed to my mom's house. They're both rules, but they're different rules, right? So depending on where we are, different rules are going to apply, and they should, because my role as an academic and as someone working in this area is very different than my role as an expert witness. In the same way that, like, an attorney can argue two different positions in two different cases, right? It's just a different professional obligation.
And have there been times when in your role as an expert, you've reached the opinion that
I'm gonna jump. This is so outside across.
Have there been times in your role as an expert where you have found, or you reached the opinion that the officer acted reasonably consistent with generally accepted principles and practices, even though you didn't necessarily agree with that principle or practice being generally accepted?
Yes. There are situations where I think there might be better promising practices, but that's not my role as an expert to assess better promising practices, right? My role as an expert to say, at the time, what was generally accepted, and that's the answer. It either is or was not.
So when you're retained as an expert, is it to not analyze whether or not an officer was using the best practices or whether or not the actions were reasonable?
I'm sorry, ask that again?
When retained as an expert, is your role to analyze whether or not the officer performed the best practices or just whether or not those practices were reasonable?
Yeah, as an expert, I do not assess whether the officer acted consistently with best practices. It's just whether they were reasonable, professionally appropriate, under generally accepted practices.
And have there been cases where you've been retained where you did find that an officer acted appropriately, consistent with accepted principles and practices?
Yes, yes, there have been.
Have there been numerous times?
There have been numerous times. Some of them don't go to trial. Some of them, especially retentions by a prosecuting office, I issue a report or testify in grand jury, and there is no criminal trial because there is no indictment or prosecution, right? Or in cases that do go to trial, there are typically split opinions where not everything an officer does is inappropriate. There are things that might be entirely appropriate in the scope of the actions that I'm reviewing. So that's part of the overall opinion too, even if what tends to get focused on in litigation is the specific things that officers may have done wrong.
And Professor Stoughton, it's been talked about how you weren't a police officer in Ohio and you're not an Ohio guy. Does that have any relevance to determining the generally accepted police practices and procedures?
No.
Would that vary state to state?
In the context of this case, no. Cars run over people in South Carolina and Ohio.
And you were shown during cross-examination a quote or a head note from State v. White when it talked about experts not engaging in armchair reflection and about what an officer could have, should have done. Is it also generally accepted in policing when evaluating a use of force not to use that type of armchair reflection?
Yes, absolutely.
Does that mean there can be no consideration about what an officer should have done?
No. So there are two different reasons that policing might review an officer's actions, one of which is to see whether the officer or any other police employee did something wrong. Separate and apart, we might look for whether there are things that the agency as a whole might do better, whether there are changes to training or policy or equipment that might improve future outcomes. The way that I understand White and the general prohibition on the sort of armchair quarterbacking is don't confuse those two things, right? Just because there could be something that was better that would have led to a better outcome, that does not necessarily mean that an officer did something wrong. Sometimes an officer does something wrong, and if they hadn't done that thing wrong, it probably would have led to a better outcome, but the focus is on whether they did something wrong, not the sort of alternatives.
And in this case, what did the defendant in fact do?
He stepped in front of a car. He stayed there for a total of about 10 seconds. When the driver of the car turned the wheel, he drew his gun and remained in front of the car for more than another 4 seconds. As the car started to move, he continued to remain in front of the car for another 2 seconds, and he ultimately shot and killed the driver.
And were those actions consistent with generally accepted police practices?
No.
May I have a moment, Your Honor?
Okay.
Nothing further, thank you, Your Honor.
Any questions as a result of this?
None necessary, Your Honor, thank you.
All right, you can step down.
Thank you.
All right, ladies and gentlemen.